Hi everyone, I think a few more people are coming in, so we'll kick off in the next few minutes. Well, good morning, everybody, and a very warm welcome to BDB Pitmans' latest employment webinar, where we'll be looking at everything you need to know when you're carrying out a collective redundancy consultation process. For those of you who don't know me, I'm Nick Lariche. I'm one of the partners in the employment team, and I am delighted to be joined by two brilliant speakers today, Chris Greep and Zoe McQueen, who will each be looking at a different aspect of the collective redundancy consultation process. Although the Chancellor announced a number of measures yesterday, which were to support the economy even further, and that includes a job retention bonus of £1,000 for furloughed employees who are employed until the end of January next year, he did also confirm that the furlough scheme will definitely be ending at the end of October. Given how much uncertainty many organisations are facing at the moment, the Chancellor's measures seem unlikely on their own to prevent the type of restructuring processes that will trigger a collective consultation requirement. In a moment, Chris Greep will look at when the duty to collectively consult arises, what time limits you need to have in mind when you're conducting these procedures, and as well as what can often be a really tricky issue of what an establishment is for collective consultation purposes. Chris will also talk about what can happen if you get the process wrong. And this is really, really important because there can be both criminal liability and significant financial compensation awarded if the correct procedures aren't followed. Zoe McQueen will then give you a step-by-step guide to what these procedures are, including how long you need to consult with, who you should be consulting with, and what information needs to be provided. Zoe will also talk about whether the current circumstances of COVID-19 can give you a get out of jail card to avoid collective consultation, and what special considerations you need to be thinking about at the moment about, as many people will still be either working remotely or be furloughed. And I've seen we've had a question about the type of things you need to be thinking about in relation to the consultation process here. Before I hand over to Chris, I'd like to cover a couple of housekeeping points if I can. At the bottom of the screen, you will see your normal kind of Zoom functions. And can I point you in to the Q&A button in particular? This is where you can ask questions about what we'll be talking about today. and we'll try to deal with these at the end of Chris's and Zoe's slots, as well as at the end of the webinar session. If there are questions which we haven't had a chance to cover today, we'll be sending you all our responses together with today's slides and the recording of the webinar by email in the next few days. But I'm hoping we'll get through a good number of questions today, and we want the session to be as interactive as possible. So if you do have any points you'd like to raise or any questions, we'd love to hear them. Just make sure you use the Q&A button and not the chat button. I think those are all the main housekeeping points. Thanks again for joining us today. And I'll now hand you over to Chris Goot to kick things off. Chris.
Thanks, Nick, and good morning, everyone. So as Nick just mentioned, I'm going to be discussing today when the duty to collectively consult arises, and also what can go wrong if you don't follow the process properly. But before we get started, we've got a poll for everyone who's here today, just to see if they have had any previous experience with any collective consultation. So that should just appear on your screen now. So if everyone could please vote. Okay, so it's quite tight on the yes and no. So 44.
Yeah, it's a good split, isn't it? We've got a good mixture there. So
yeah,
hopefully there'll be a lot for everyone to think about through the session today. So no, that's really interesting to see.
Definitely. Okay, brilliant. So the first topic I'm going to be looking at today is on when does the duty to collectively consult arise. So the main piece of legislation we're going to be looking at is the Trade Union and Labour Relations Consolidation Act 1992, which is a bit of a mouthful and has been abbreviated to TULRCA throughout the presentation. So the main section is section 188, which covers the duty to collectively consult, and this applies where the employer is proposing to make 20 or more dismissals that will take effect within any 90-day period or less at one establishment. So there are a few key factors to break down within that definition. So what we're going to be mainly considering today are who the employer is, who the affected employees could be, what a proposal means, what 20 or more dismissals in 90-day period means, and what is one establishment. So looking at the first point, which is who the employer is, so that's been defined in section 295 of TULRCA, and the employer is the legal person by whom the employee is employed. So that means that it is the distinct legal entity that actually employs the employee and has that contract of employment with them. So what this means is where there is potentially a parent company who is proposing redundancies within one of their subsidiaries, it would be the subsidiary that would have the obligation to inform and consult with their employees and not the parent company. Where there's group companies involved, what this means is the separate employers will have the responsibility for the purposes of collective consultation. So even if both group companies are based in the same geographical location and each propose to make, say, 19 redundancies, neither would have the obligation to collectively consult, and each company's proposal would be considered separately. So next slide, please. So here we'll be looking at which employees are covered. So the definition in the TULRCA is an employee who has entered into or works under an employment contract. And unhelpfully, there is no statutory definition of what an employment contract is. And so you look at the usual common law test to determine employment status. So looking at the key factors of things such as personal service, levels of control, and mutuality of obligations. There are some employees who are excluded from the duties to collectively consult, and those are the categories listed on the slide, being any fixed term contracts where the proposed dismissal would take effect on the expiry of the fixed term, any share fishermen and women, Crown employees, House of Lords and House of Commons staff, and police officers. One of the key problems that some employees may have is what the issues are about overseas employees. So the key question to look at when talking about employees overseas is not necessarily the connection the employees have to Great Britain, which is the normal test to see if jurisdiction applies. It would be whether the establishment that the dismissals are taking effect in has sufficient connection to Great Britain for local laws to apply. The next slide, please. So here we're talking about a proposal to dismiss, and when does that reach the stage that the duty to consult arises? So again, there's no set definition, which can be quite unhelpful in these sorts of issues. But what there has been decided is that a proposal is at an earlier stage than actually deciding that the redundancies need to take effect. And this is because employers can't effectively consult with employees if they have a closed mind, or they can't effectively consult over something that has already been decided to take effect. And so consultation needs to begin whilst those proposals are still at a formative stage. And so more than contemplation is required for the possibility of redundancies. And so before the duty to consult arises, employers' decision making will need to be sort of well advanced to have identified the fact that over 20 employees would need to be dismissed as redundant in that establishment within that 90-day period or less. It's also important to consider the fact that employers may propose the redundancies even though alternatives are being considered. And an example of this is a case called Scotch Premier Meats Limited and Burns. And what happened in this case was there was financial difficulties, which led to the employer deciding that they would either need to sell the business as a going concern or just close it down completely. Now, closure would have led to 155 redundancies, and so a voluntary redundancy program began, but the employees were never informed of the possible sale of the business. The Employment Appeal Tribunal held that the employer had formed a proposal to dismiss as redundant 20 or more employees when it was considering the two options that it had, being sale of the business or complete closure of it. And the fact that an alternative course of action was also being considered as well as the redundancies did not mean that the collective redundancies weren't being proposed. And so the Employment Tribunal held that they should have gone through and started the collective consultation process. Next slide, please. So now we're on to a topic which can be slightly complex, and we're discussing the time limits. So as previously discussed, the collective consultation duty arises where there are 20 or more dismissals which can take effect within a 90-day period or less. And for these purposes, it's important to note when a dismissal takes effect, and that is the date that the employment contract comes to an end, and not when notice expired, not when notice is given, excuse me. So it's all about when notice expires and not when notice is given. So essentially, the statutory duties are looking at a rolling period of 90 days to see whether any employer's proposal will result in 20 or more dismissals within that rolling 90-day period. It's important to note that any voluntary redundancies that are as a result of a proposal by an employer are still included within the number for that 20 or more dismissals. So when determining the number of dismissals that are proposed, no account is given of employees whose consultation has already begun. Now, what this means is that should an employer have proposed, say, 30 redundancies, they would need to begin collective consultation. They would then propose to make another 10 redundancies within the same overall 90-day period. But because the consultation has already commenced on the original 30 redundancies, the subsequent 10 redundancies would be viewed in isolation, and there would be no need to or obligation to collectively consult about those additional 10 employees. Importantly, though, they would need to still be included on the HR1 form to the Secretary of State if that had not yet been submitted, and we'll touch upon that HR1 form again a little bit later on. So we've just got a couple of examples for you on the next slide of those time limits, just to sort of break that down and see where we go with those. So in the first example, say in mid-June, an employer would identify that they need to make 35 people redundant by the end of July, and so they commence collective consultation. A little bit later on in early July, so still within that 90-day period, the employer concludes that a further 10 would need to be included in the same round of redundancies, and that would all need to take effect by the end of July. So does the employer here have to commence collective consultation in relation to those 10? So the answer here would be not. So as required by the TULRCA, this allows the employer to discount those employees where collective consultation has already commenced. And the second example we have is where an employer is proposing to dismiss as redundant 19 employees in the next 90 days. They would also then propose to make a further 18 employees redundant within a period of 90 days from the date when the last dismissal from the first round of 19 was implemented. Now, in this situation, the staggering of dismissals would be acceptable because the second round of redundancies, being 18, would take effect after the first round of dismissal had taken effect and after that 90-day period, and so the second bunch would not be included within that first 90 days. But ideally, this could lead to additional problems within the business, as you would want to be considering all of the redundancies at an initial stage, looking at your business case for why the redundancies are necessary, and then establishing what roles are going to be needed moving forward, which employees could potentially be affected, and so potentially staggering them in this way could lead to further complications later down the line. And by purely looking at the broader picture early on, you could save time and expense from doing it in this way. So next slide, we're going to be looking at the topic of one establishment. And so this can be a fairly complex issue. And so what we need to look at here is what establishment means. And the European Courts of Justice have given some guidance on this in a number of different cases. And so the definition here, an establishment means the unit to which the workers made redundant are assigned to carry out their duties, and so that then constitutes the establishment. So it's all about the entity that the employee is working for and carrying out their duties. And some further guidance was then given on what an establishment should be interpreted as, and this should be interpreted very broadly, so to limit as far as possible cases of collective redundancies which are not subject to the directive of collective redundancies. And an entity may consist of individual business units or local establishments, but the entity may have a certain degree of prominence and stability. It may have been assigned to perform a set number or a different number of individual tasks, and it may need to have a workforce or the technical and organizational structure to allow it to do so and carry out those tasks, and it may have a physical presence. What the courts have also said is there is no need for the entity to have any legal, economic, financial, administrative, or technological autonomy, a management which can independently effect the collective redundancies, or geographical separation from the other units and facilities of the undertaking. So it's important to note here that it's not just about geographical separation. There is a lot more to consider. And one of the main topics and cases here is the Woolworths case. So it's always worth bearing in mind Woolworths and remembering them for this and not just their sort of fantastic selection of pick and mix. So this arose following the insolvency of Woolworths. So they went into administration in November 2008. And of course, large-scale redundancies followed. So the Employment Tribunal awarded a number of protective awards for failure to inform and consult under the TUL RCA, but only in respect of those employees who worked at stores with 20 or more employees. So the main issue in this case was whether each individual store was a separate establishment for the purposes of collective consultation, or whether all of the employees working across Woolworths should have been aggregated and a consultation take effect with each employee. So the courts held in this case that the directive denotes a local employment units which the workers have made redundant and are assigned to carry out their duties. So the Employment Tribunal held that each store was a separate establishment for the purposes of collective consultation, and so the duty to inform and consult had not been engaged in stores with fewer than 20 employees, and those employees were not entitled to a protective award. So it's always worth bearing in mind the factors that are noted here, and also worth doing an analysis of the business and of all the separate entities that are involved and each separate stores to have a look at whether they would be classified as an individual establishment for the purposes of collective consultation. And so the next slide, please. There are just a couple of practical points to have a look at when you're doing your analysis of establishments. So looking at the operational independence of the groups of staff at each location, any shared support functions that there may be, so HR, payroll, accounting, those sorts of functions, and whether employees working across sites or being relocated on a temporary or permanent basis from one site to another. And whilst it's important to always consider the geographical location and the organisational approach, it may often lead to the same outcome, but it is always very important to analyse it on its separate basis, so that you're not sort of falling foul of the individual establishment point. So now we're looking at getting it wrong. So one of the really, really important things that really must be remembered when looking at a collective consultation is the HR1 notice. And this needs to be supplied to the Secretary of State where there is a proposal to dismiss as redundant 20 or more employees at one establishment within 90 days. And that one establishment is defined in the same way as previously discussed. Employees who work outside of Great Britain aren't counted for these purposes on the form. And the main point to remember here is that failing to provide the notification to the Secretary of State is a criminal offence, and the employer will be liable for an unlimited fine. So again, sort of emphasising the point here that it really is important to make sure that that form is done and sent in before the proposals are substantiated and the collective consultation begins. So what else can go wrong if you fail to follow the proper processes, and if you are looking at those 5 points of what a collective consultation when the duty arises, and you would maybe perhaps get any individual point there wrong, you would be potentially liable for a protective award for those employees who are able to bring claims. Enforcement of the claims are by way of complaint to the Employment Tribunal. So employees can complain in relation to a breach of the rules relating to employee representatives, which Zoe will touch on shortly, and then the failure to inform and consult a bit more generally. So if the tribunal are to find that a complaint under TUL RCA is well founded, then they must make a declaration to that effect, and they may also make a protective award. So the protective award, that is based on an actual gross weekly pay for each week of the protected period, that being up to 90 days, and then a proportional sum for each part of that week. And so it's really important here to note that it's based on gross weekly pay and not subject to the statutory cap that a statutory redundancy payment would be. So the tribunal will look at a number of different factors. They will make the award that it considers just and equitable in all circumstances, looking at the seriousness of the employer's default. And protective awards are here to be punitive rather than compensatory. So the question for the tribunal is, how serious is the employer's breach, and not looking at the actual loss suffered by the employees. So that leads on to the factors that the employment tribunal will consider. So they'll look at the seriousness of the breach. Was there a technical breach, or was there just a complete failure to consult? Was the failure deliberate? Was there legal advice available to the employer about the obligations that they had? Are there any mitigating circumstances involved? And were there any failure of the employee representatives to consult with the organisation? So on the next slide, we just have some examples of some protective awards that were given by the tribunal, and just a very brief synopsis of the amount of days awarded and some information about those. So one of those, the third one there being 60 days paid where there was a complete failure to consult, but 90 days would have meant the unlawful trading whilst insolvent. So that's where the tribunal has their ability to award payment awards that are protective awards that are just and equitable in the circumstances. So even though if they had been able to continue to trade, they would have been awarded a 90-day protective award, in the circumstances a 60-day award was appropriate. And the next slide, please, is just getting it wrong and then touching briefly upon unfair dismissal. And so failure to follow a fair and reasonable consultation process in line with the obligations under TU LRCA can leave exposure to unfair dismissal claims. So it may make it harder to defend any unfair dismissal claims that are brought against you should you have failed to collectively consult or to properly think about the obligations that you have for collective consultation. And so that can make it fairly difficult to defend any unfair dismissal claims moving forward, and that can then lead to compensation of the lower of a year's salary, or £88,519, which is the updated figure for this year. And so I think, Nick, if there's any questions, I think that's back over to you.
Brilliant. Thanks very much, Chris. Yeah, we've had a number of questions. I think Zoe's going to be touching on some of those, so I will kind of leave those for now, but if we can just pick up on a few, Chris. So we've had a question about whether kind of failed probations would be counted for kind of collective consultation purposes. Do you need to take those into account?
I think the key point to talk about there is the reason for the dismissal in that case. So the collective consultation here is about dismissals that are being by reason of redundancy. And so if the failure for probation is because of, say, conduct or capability, then they wouldn't be needed to be consulted or counted towards the numbers in this case, because the reason for dismissal is not redundancy. If the failure for probation was because of redundancy and the situation that the business is facing, then they would likely need to be considered in the numbers for that.
Yeah, I think it's important just to be aware that kind of dismissal here is quite wide, but at the same time, it doesn't include dismissals that are kind of relevant directly to the employee. So as you say, performance and conduct, if there are organizational or economic reasons behind the probation being failed, then that's probably going to be taken into account. But as you say, Chris, if it's kind of performance or conduct, then that's probably not going to be relevant for collective consultation purposes. We've also had, of course, we've had a question about establishments. And do you think that establishment can be an area of work at a specific location, i.e. a workshop at one geographical location. You got any kind of thoughts about that?
I think potentially, I think you'd need to look at whether the workshop would have the factors that the court set out, and looking at whether they have those essential tasks that they've been assigned to perform. Is there a workforce in place to allow that establishment to actually put into practice the tasks that they've been asked to do, and whether they have that degree of prominence as to be a separate entity within the business.
Yeah, I think, you know, traditionally everyone's always kind of looked at geographical kind of location as being a main establishment. You know, I think in this kind of day and age, you could look at business units as well. But whatever test you use for establishment, I think you've got to be consistent. And, you know, I think, as you've said in your talk, Chris, I think you need to do quite a careful kind of analysis of how you organize kind of your business to see what establishment kind of really fits for the way you run things. Okay, I think I will hand over to Zoe now, and we'll pick up some more questions at the end of the session. Zoe, over to you.
Good morning. Well, thanks very much, Nick, and hello everyone. So Chris has given a really good overview of when the duty to undertake collective consultation arises in a redundancy situation. And what we're going to do now is cover a recap of the process itself and the statutory obligations that imposes. So as a starting point for looking at the process, what's really helpful to consider initially is actually to refer to the principles of fair consultation that were set down by Lord Justice Glidewell in what's known as the Price case. These principles emphasise the importance of both information sharing and active engagement on the part of the employer, who should be entering into the collective consultation process with an open mind. For me, the final point on the slide really summarises the spirit of consultation, which is giving the body of employees a fair and proper opportunity to understand and to express its views, and with those views then being properly considered. So now that we've all got into the spirit of openness and engagement, I'm going to run through a high-level overview of the key practical elements of this process. How do we put fair consultation into effect? So as Chris has already covered, the duty to inform and consult arises where an employer is proposing to make redundancies of more than 20 employees within a period of 90 days or less at one establishment. So the magic section 188 threshold imposes certain statutory obligations on the employer in terms of process, requiring them to provide specified information, to consult on its proposals in a very prescriptive way via representatives, and to make the relevant notifications to the Department of Business, Energy and Industrial Strategy. As set out there on the slide, the length of the minimum consultation period depends on how many redundancies are being proposed. These are, however, minimum periods, and consultations often last longer than this, although there's undoubtedly a balance to be struck between giving enough time to meaningfully consult and not doing this so far in advance that it's unnecessarily protracted. Whilst it might sound really obvious, the most practical way to ensure that you don't fall foul of time limits and that you hit all of the necessary steps involved is to collate a comprehensive consultation timetable. This is helpful for both those organising the consultation process, planning resources, making sure they've got time to get their documents sent out and in order, and also for the employee representatives, so that both sides can understand what is happening and when. Collating this timetable is also really useful to identify any external factors, like bank holidays or key work events, like financial year end, for example, which might have an impact on employees' availability. This is even more important at the moment, given logistical issues caused by coronavirus. For example, if employees are furloughed or working remotely, it might take that little bit longer. In relation to the final point set out on the slide there, I should emphasise that although the employer is obliged to conduct consultation with a view to reaching agreement, it's not required to agree to any counter proposals made by the employee representatives straight off the bat. However, the process of consultation is much more akin to negotiation than a simple exchange of opposing positions. Right, so who actually needs to be informed and consulted under section 188? And the answer to that is appropriate representatives of the affected employees. And there are two elements to this. So firstly, let's look at who the affected employees are. This term tends to be interpreted on a pretty wide basis and covers, as you'd expect, those who might be dismissed by the proposal and those affected by any measures in connection with the dismissals, which might include, for example, those affected by new systems of work or reporting lines or proposed variations to contracts of employment. Looking then at appropriate representatives. Now, this is an umbrella term that covers three separate potential categories of individuals who will be the key point of contact between the employer and the affected employees during the collective part of the process. In terms of which category applies, the rule is that employers must consult trade union representatives where the affected employees fall within a category where, in respect of which, an independent trade union is recognised. So it's not necessarily about the fact that those affected employees are members, it's about the category that they belong to. Where there's a recognised union, but it's not recognised in respect of all of the affected employees, the employer must consider other appropriate representatives in respect of those employees that are outside of the bargaining unit. So you might have a few issues or different practical issues you've got to negotiate there if that's the case. So only where there's no recognised trade union does the employer have a choice as to whom to consult. And in this instance, it can either choose to directly elect representatives for the purpose of the consultation by the affected employees, or you can look at using a standing body of elected or appointed representatives. Now, in practice, most employers will go for the first of these options for two main reasons. Firstly, electing representatives specifically in relation to the consultation exercise allows them to consult with those specifically affected with the redundancy proposal. Secondly, the conditions under which a standing body of representatives can be legitimately consulted is unclear, and there is actually quite little guidance about how you would go about demonstrating that that body does have the authority to be consulted. Given this risk, and as Chris has touched upon, the risk of having a protective award made against you, many employers choose to simply opt for the first option and elect them directly so that they just don't take that chance. So if we've determined that we're going to undertake employer representative elections, how exactly do we go about that? Well, the requirements for the election process in these circumstances is also prescribed by statute under section 188A. And the obligation is on the employer to make such arrangements as are reasonably practical to ensure that the election's fair. And actually, if you have a look at section 188A, these really are quite prescriptive. So there are a number of the key points that the employer has to consider here to ensure that the representatives sufficiently represent the interests of all affected employees with regards to the number and class of employees. The employer must first determine whether different classes of affected employees will have their own representatives, which is known as the constituency approach, or whether you will just elect representatives who represent the entire affected employee body as a whole. It can be really useful to think ahead of time what you would do if you end up with more candidates than originally anticipated in this process. For example, if you proposed and you provisionally planned for 2 candidates in respect of a particular group of employees, but you receive 3 applications, would you be content to operate with 3 representatives to avoid the need for a ballot? Or is that something that you think is really important to insist on? So all candidates for election of the employee representatives must be affected employees on the date of the election, and no affected employee should be unreasonably excluded from standing. All affected employees on the date of the election are entitled to vote, and they're entitled to vote for as many candidates as there are representatives for their particular class of employee. The election should be conducted to ensure that, so far as is reasonably practical, voting is in secret and that votes given at the election are accurately counted. There's no specific time frame for actually undertaking the election process. However, it's worth being mindful of the fact that consultation must begin in good time, and this can't start, and therefore the relevant moratorium on dismissals won't start to run until after representatives have been elected. So once we've got our appropriate representatives elected and our time frame set up for a consultation process, we can start thinking about some of our statutory notification obligations. So separate to the duty to inform and consult, the employer must also notify the Secretary of State for Business, Energy and Industrial Strategy that the potential dismissals are contemplated. And this is done by completing and sending in the form HR1, which contains key information about the proposed redundancies, such as the numbers contemplated. And it also includes the identities of the employee representatives. As set out on the slide, there are different minimum notification periods, depending on whether 100 or more redundancies are proposed. But it's worth remembering that the notification time runs from when the form is received by BIS, not when it's sent. It might be less of an issue, given that this is now done majoritively by email. Once BIS has been notified, it's imperative that a copy of the HR1 form is then sent to the appropriate representatives as well. Chris has already mentioned it, however, it's really worth emphasising again that failing to submit the HR1 form within the relevant time period without good cause may result in prosecution and the unlimited fine that Chris mentioned. And that is for the company and for the officers of the company. So you really are looking at quite serious liability potentially there. So let's now look at the consultation process itself. And this comprises two broad stages. First, the provision of written information to the representatives, and secondly, the process of consultation on the proposed redundancies. So taking stage one first, which is on this slide, the important thing to emphasise here is that both the content of the information to be provided and how it's communicated are both very important. Whilst you might provide the prescribed information to all affected employees at the outset of the process, for example, before elections take place, it's really imperative that you resend this to the representatives after the election process as well, because otherwise the information will arguably have not been provided specifically to employee representatives for the purposes of consultation. It's not necessary for the employer to provide all of the statutory information at the outset of the consultation, although this is best practice. Whilst this is the case, case law does indicate that consultation can be deemed to have commenced as long as the employer has provided sufficient information to enable meaningful consultation to take place. So, for example, you might not be ready at the outset to give details of proposed selection criteria and how the process will be undertaken. You can provide this at a later stage after consultation has begun. For example, if you've already started talking about ways of avoiding or reducing redundancies, but the key thing is that the information is provided at some point. In terms of precisely what information has to be provided to representatives, this is set out on the next slide. As you can see, this is key information about the proposed redundancies that actually the employer should already know or have worked out, including things about numbers, selection and dismissal processes, and the method of calculating any redundancy payments. It also includes suitable information about agency workers, which relates to what they're doing, where they're based, and essentially what role they're fulfilling within the organisation as a whole. So it's not just in relation to the part which has been denoted as the establishment, if, for example, that's a team within the business. It's possible that there will be changes to the proposals during the consultation process, and some of the specified information might change. And that's actually one of the big reasons for the process existing. The employer's obligation is therefore not to just provide this information at the start of the process. It's a continuing obligation. So as things evolve, keep people updated. So moving on now to stage two, and that's the substance of the consultation process. As you recall from Lord Justice Glidewell's guidance, consultation with an open mind on the topic set out on that slide there is mandatory. Breaking these points down, I think it's fair to say that requirement to consult over ways of reducing the numbers of employees to be dismissed and mitigating the consequences of dismissal is relatively straightforward. The obligation in this respect is clearly to consult about whether all of the redundancies are required, the level of redundancy payments that would be made, and other efforts to assist employees, such as redeployment or outplacement assistance. Slightly more controversial is the scope of the requirement to consult over ways of avoiding the dismissals, since this implies an obligation to consult about whether redundancies should take place at all, and that will accordingly include consultation on the business case for the redundancies. The key touchstones that employers should keep at the forefront of their mind through this part of the consultation process is: what is the issue or problem that we're trying to solve? Is it about headcount? Is it about reducing expenditure in a certain area? Have we got no demand for a particular item? This approach helps the employer explain how the situation has arisen to employees and why it's contemplated that this is a genuine redundancy situation. In terms of practicalities for conducting the consultation process, this is likely to be undertaken by way of representatives being given the relevant information, canvassing their relevant affected employees, and then reporting back to the employer for discussion, either at a meeting or in writing, and then reporting back with any outcomes or developments to the employees. And this is quite just a general cycle that may need a few runs through, particularly if there are proposals which need to be considered going back and forth. In the current climate, one of the primary issues to bear in mind when undertaking a redundancy consultation process with staff who are furloughed will be the obvious logistical issues which are likely to arise from consulting with staff remotely. In terms of the interaction between furlough and consultations, the government guidance has confirmed that employees can take part in consultations whilst on furlough, and that employee representatives can undertake their duties whilst on furlough as well. So notwithstanding that both Chris and I have been banging on about how important it is that employers carry out their statutory obligations, there are certain circumstances where an exception applies to the obligations set out there. The exception is limited because it doesn't apply to all of the obligations set out of Section 188, and there are a number there, nor does it necessarily remove those obligations entirely. If you think that the special circumstance defence applies, you should then still take all such steps towards compliance with that requirement as is reasonably practicable in those circumstances. And in terms of when this actually matters, the key thing is looking at, well, is this something that's been foreseen? Is it something really sudden that's come out of nowhere, a real sudden disaster? Because in order to rely on the special circumstances defence, an employer has to show that there are circumstances. It's not a case of showing that circumstances render compliance not reasonably practical. There's no generic category of special circumstances, and whether or not that is the case will be judged on the facts of the case. But there are things that it won't necessarily automatically involve. For example, insolvency in itself isn't necessarily a special circumstances defence. And I think in relation to the current coronavirus climate, it's really worth noting that the special circumstances defence is less likely to apply to redundancies happening now, because the initial urgency of redundancies may well have passed. And certainly as and when the furlough scheme ends, it will certainly have passed at that point. So it is really important that you do comply with your statutory obligations as far as you absolutely can. So to finish up, I've set out some practical points to bear in mind when contemplating collective redundancies. In addition to the relevant time limits, we've talked about by stage 1, information sharing, and stage 2, the consultation process. And in both of these respects, setting a comprehensive collective consultation timetable, also with reference to the individual consultation timetable, is imperative. In the current climate, allowing extra time for logistical issues is more important than ever, so do consider extending timeframes where necessary and making adjustments as and when you need. Keeping an open mind and engaging in collective consultations and meaningfully considering alternatives are also extremely important components of running a fair process. As discussed, keep referring back to the key issue or problem driving the process, because that's extremely helpful to keep focus and to show that there are genuine reasons for why the redundancies are being proposed. I hope this recap's been helpful, and I'm of course happy to answer any questions.
Brilliant, thanks very much, Zoe. Yeah, we've had a couple of questions, and one of those is about what's happening at the moment. How do you consult with reps and individuals remotely? Can you have breakout rooms? How would you kind of go about kind of doing that process when you're not able to meet face to face?
Well, I think certainly making use of remote technologies are going to be really helpful here, and certainly some of the guidance is talking about making sure that not necessarily just for this, but for other redundancy consultation meetings, that you do give opportunities for people to be accompanied by via Zoom. And I think one of the best ways to avoid that is to try and get things in writing, give extra time, and just schedule in appointments so that the representatives are getting the time with those employees.
Yeah, absolutely. I think there are ways. I think we've all been managing, to do a lot remotely now, and there's a lot you can do. It's just trying to mirror the usual processes as much as you can, really. I think. I had a really good question about employee reps and whether you can, potentially exclude people who are subject to disciplinary sanctions or who've got a bad disciplinary record or performance concerns. I'm not sure there is there is very much scope, but I can think practically that you might want to maybe place limits, but I'm not sure that there's too much under legislation that allows you to do that.
No, I think just that the legislation essentially just says you can't do it unreasonably. So I think you'd probably want to look at the reasons why you're objecting to them. And as you say, that does, and again, maybe think about, well, does that impact on the duty that they're being expected to actually undertake? I think that's probably just, as long as you can back up the decision and you've actually got grounds to justify it rather than just being, I don't like them or they're a troublemaker. I think that's probably just take it really steady and see what's in front of you.
And I guess as well, you think about whether there are alternative reps in a particular constituency as well. I guess if that rep was the only one who'd come forward, it might be harder to argue that they should be excluded. But if you've got a range of candidates, then it's less of an issue for the representatives and the effective employees involved. We also had another good question about establishments, and again, maybe this is something for both you and Chris to have a think about, which is where you've got establishments in say London, we've got a number of different sites. Would they each be an establishment, or would you put them together? What do you think, Chris, there, that some of the factors you should take into account?
Yeah, I think it depends on the situation and looking at each of the business functions that each unit has, the administrative functions that they carry out, and what they're able to do individually in reality, what the reality of the situation is in respect of each individual unit. If they are sort of sufficiently separate, then there would be a separate establishment, but it would depend a little bit. We'd need a little bit more information to assess it on a case-by-case basis, but just setting out by geographic location wouldn't necessarily be enough.
I think again it depends how distinct they are as units, and again you can have kind of different offices as being different establishments sometimes. So if there's a branch office of a larger office, then you've got to include those within in one establishment. So I think you need to kind of drill down, but if there's enough of distinction, I can see an argument for them kind of being their own establishment there. What do we think as well about whether any special arrangements have to be made for staff who are on long-term sick leave? Maybe they're off with work-related stress and they might be reluctant to meet with the HR team and the managers involved. Do you think there are any kind of special things that you might need to think about there in terms of the consultation process? I'll throw that open to Zoe. Process.
Yeah, I mean, I think you certainly would want to consider that, and I think that probably you should probably be looking at under the guise of the individual consultation process in the first instance, and certainly how you go about administering that will hopefully then feed into the collective side as well. But certainly you will need to take care of people who are on long-term sickness absence, see what adjustments you can put in place, and essentially just take some steps to make sure that you can demonstrate that you've done whatever you can that's reasonable to get them actually engaged and consulted.
Yeah, absolutely. I think that's exactly right. And obviously, yeah, as you said, you've got the potential duty to make reasonable adjustments. So think about whether there are kind of particular disadvantages that individuals will face with the process. Maybe allow for a longer time for the consultation process. Think about how the information is relayed to them, and whether, or try to avoid as far as you can do, them being disadvantaged because of their particular condition. And I think again, it's with all of these things, it's great to be able to show that you've considered these issues, and you've given some thought about, you know, trying to avoid people being, you know, trying to be disadvantaged. Let's just check whether we've got any other points. I think, as I said, you know, if we haven't had a chance to answer them today, we will pick these up. I had one question about if the redundancies are going to be more than 90 days. Again, I think this comes back to when the redundancies will take effect. Is that right, Chris?
Yeah, it's all about when the redundancies take effect. So the date that the dismissal occurs, not the date that notice starts to run.
Brilliant. Great. Well, I think that's pretty much everything for today. Thank you very, very much for joining us. Thank you for our absolutely brilliant panel. Zoe, Chris, you've been fantastic. Thank you as well to Melissa. She's been working tirelessly behind the scenes, organising all of this, and it's been great. So thank you, everyone, for all your help. Again, thank you for joining us. You've asked some brilliant questions. Thanks for engaging with it. It's a really interesting issue, and we've kind of appreciated seeing all of your thoughts there. As I mentioned, in the next few days, we will be sending out an email providing, you know, fuller responses to the questions you've asked. Along with that, we'll be sending out a recording of the webinar together with the slides that Zoe and Chris have prepared. And yeah, that should be going out in the next few days. Our webinars will be going on a short August staycation shortly, but they'll come bouncing back in September. So please look out for the invites to those. In the meantime, again, thank you very much for joining us. You've been great. Have a great day, and I look forward to seeing you all again soon. Thank you very much.